It is time to check in with Chris Dimakos, our CJAD 800 legal contributor. So, Chris, a couple of really interesting stories here today with two very different sort of perspectives. Number one, we often talk about landlord-tenant situations. It's funny that you have this today in your topics because I was just hearing from someone who is going through this exact same experience with a family member. Landlord tries to repossess an apartment from a tenant who has been living there for 17 years, always paid rent on time. And of course, the reason here, and this comes up a lot, as I said, the landlord alleging that he wants to move a family member into the building. So I know we've discussed this before, but I thought laws in Quebec either are changing or have changed to allow this not to happen. Where are we on this?
Yeah, so first and foremost, there's always been a provision that allows a landlord to take back a dwelling on the condition that it's for certain members of their immediate family, that's what they're allowed for, but they have to meet a whole bunch of criteria. And over the years, the criteria continues to get a little more, I would say, onerous in terms of how strict it is. And you can't just throw somebody out anymore that's been there for 17 years. Now, the funny thing about this judgment, it was a BC judgment, but it was based on the exact same issues we have here in Quebec. The landlord showed up with a whole bunch of financials showing that, hey, it's cheaper if I move my family member into this apartment. All the numbers make financial sense. But what the tribunal said was, you're missing one thing here. And you have to be genuine and you have to have good faith when you do that. And nothing about the financials that the landlord presented was able to satisfy that requirement of good faith. Basically saying, are you really doing this because you have no other choice? Or are you doing this because the tenant's been there for 17 years, they're paying a lot less than what other tenants are doing, and this is just a way to get them out and move a family member in, even if it is temporarily, so that you can get somebody else in there paying market rate. So the one thing that you should always remember if you're a tenant and you get one of these notices of repossession, it's not enough for the landlord just to show it makes financial sense for me to move somebody else in here instead of keeping you. What the courts are now saying is this is someone's home. Maybe they're not the owner of the actual brick and mortar, but it is their house. It's their home. It's where they live. It's where they set their roots up. It's where their kids go to school. It's where they work. So if you're going to remove somebody from their home where they have their roots, even if they're not the owner of the building, you need to have good faith to back up what you're saying. And I think that this is going to be a judgment that's going to be often referred to by tenants saying, the landlord's saying this, makes financial sense. But the truth is they just want me out of here because I'm not paying market rate for where the rents are. And we've known what's happened to rents over the last 5 or 6 years in this country, not just this province. So it's an important judgment, and it refers to and it's important that people understand this. It's the intention. It's what is the genuine intention here. It's not about only financials and how I can save money by doing this. It's more convenient for me to do this. It really has to be, the tribunal has to be persuaded that this is your last resort. It's your only option. And we're going to allow you to do that if that's the case. But otherwise, we're going to reject your repossession attempts.
Look, I wonder, too, that the problem with these situations is, right, if you go ahead as the tenant and you leave and you find out after the fact that that's not, in fact, what happened, he's not moving in a relative, where's your recourse here? Because that doesn't help you at all, right? That could take months to get done.
Right. There is a recourse. You can collect damages for that, and all the money, it's not indefinite, but it does cover you, and people have secured not only hundreds but thousands of dollars in damages for landlords that have evicted them based on that premise of repossession, and they ended up finding out that they put it for rent only months afterwards. So, there's a monetary settlement or judgment you can get, but if you speak to those tenants, the fact that they had to uproot themselves, it's not all financial. It's not just monetary. There's a lot that goes into moving where you live and where your kids go to daycare and where your kids go to school and where you work. So there's a lot of non-financial issues and prejudices that you suffer that you may not be able to collect. So it's not a good situation. And the more you mentioned it right off the top, you talked about the fact that more and more, with all of the new judgments that keep coming in, it's getting more and more difficult for landlords to do this when their intention is really not what appears on the page itself. So this is another judgment that basically reinforces the obligation of the landlord proving that they're genuine and it is of good faith what they're doing. It's almost like, I have no other choice. I don't want to do this, but I have to do this. And in those cases, they'll approve it. Otherwise, you run the risk, like this landlord did, of getting your repossession attempt refused.
Okay, I don't want to dwell, at least I didn't, but I do want to go back, because as I said, I know someone, having heard from someone who finds a family member in the exact same situation and kind of wonders what to do next. Someone can tell you as a landlord, right, with good intentions, apparently, and then, of course, as I said, you find out that's not, in fact, what happened. Is your recourse first to go to a lawyer, to go to the rental board? What should you be doing as the tenant?
There's a couple of things. The first thing you want to do when you get one of these things is you need information. I stress this all the time, whether it's an employment issue, whether it's a landlord-tenant issue, whatever the problem is you're facing, you need information. So the first thing you want to find out is, when this landlord is saying that you want to repossess, what is the state? What options does the landlord have? Is your apartment the only apartment or condo that they own, or is it within a building where there's multiple places? Because if there's an alternative to your space, well, then the courts often say, well, why this place? Why not all the other apartments that you have at a market rate? How come this tenant is being particularly targeted? Is it because the rent is so low? And if you're in that situation, and if your rent is way lower than market, well, that should basically be a hint for you in saying, I'm probably being targeted by the landlord because of my rent. And that's the starting piece that you need to build your case to defend against an unlawful repossession, where they're just trying to get you out to rent to somebody else. So the first thing you want to do is that. And secondly, the rental tribunal, they have advisors that you can speak to, that you can call, that you can meet with. And there's also many tenant advocacy groups that are out there if you don't want to really spend the money on hiring a private lawyer. So there's information out there that you can get. But I would say the first thing you should do is get information about what the landlord is alleging and what the true nature is of their situation. How many spaces do they have? Is it the only one, or is there alternatives? And why are you being selected? What does your gut tell you? Mm-hmm. Is it because of the low rent, or is it because of something else? And you want to work with that and go meet with some professionals who can give you some information.
And that's where we'll have to leave it. I'm afraid we'll have to save sperm donors for next week. Okay. Chris, thank you very much. Have yourself a good one.
Thanks, sir. Happy New Year again.